Thank you, Presiding Officer, for this opportunity to update Parliament on the Supreme Court's decision to uphold the For Women Scotland appeal. The Scottish Government does, of course, accept the judgment of the Supreme Court. It is a significant legal ruling, and it is right that we take time to consider it carefully. Before I turn to the details of the judgment, it is important to recognise the tone and the temperature of the surrounding debate concerning real individuals in our community, in our workplaces and in our families, that has often been deeply distressing to them. It should be clear to all of us in this chamber, regardless of our view on any of these matters, including in the judgment last Wednesday, that it has had a very significant impact on many people. This judgment, as the Supreme Court made clear, must not be used as a licence for division and hostility. The pursuit of equality for women and for trans people is our collective responsibility. All of us in this chamber must ensure that the rights and dignity of all are upheld, and our debate must be rooted in empathy, compassion and equality. Indeed, in his delivery of the judgment, Lord Hodge, giving the opinion of the Court, said that the Court counsel against reading this judgment as a triumph of one or more groups in our society at the expense of another. It is not. Turning to the judgment, Presiding Officer, this case centres on the guidance issued for the Gender Representation on Public Bodies Scotland Act 2018 and the meaning of women set out in that guidance, which is the same meaning as under the Equality Act 2010. The Scottish Government successfully defended our guidance twice in both the Outer and Inner House. However, the Supreme Court is the final decision-maker on such legal issues, and it has delivered a carefully considered judgment. The definition of women in the guidance was the definition in the Equality Act. And as we were guided on the meaning of that definition by guidance from the Equality and Human Rights Commission, the EHRC, which is the enforcement body for the 2010 Act. As we heard in last week's judgment, issues arose from a tension between two pieces of Westminster legislation and how they interact. The question of compatibility between the Gender Recognition Act of 2004 and the Equality Act 2010 was central to the Court's ruling. In paragraph 8, the Supreme Court said that the central question in relation to the appeal was whether the 2010 Act treats a trans woman with a Gender Recognition Certificate, a GRC, as a woman for all purposes within the scope of its provisions, or whether when the 2010 Act refers to a woman and sex, it is referring to a biological woman and biological sex. The Supreme Court concluded that the meaning of the terms sex, man and woman in the 2010 Act is biological. The Supreme Court notes within its judgment that in the statutory guidance to the Gender Representation on Public Boards Scotland Act 2018, that Scottish ministers reflected the stance of the EHRC that a person issued with a full GRC in the acquired gender of female is a woman within the meaning of the Equality Act. It concluded that the Scottish Government guidance on the Gender Representation on Public Boards Scotland Act 2018 is incorrect in relation to its definition of women. The judgment also makes it very clear that trans people continue to have protection and rights. As the press summary issued by the Supreme Court on the judgment said, trans people are protected from discrimination on the grounds of gender reassignment. They are also able to invoke the provisions on direct discrimination and harassment and indirect discrimination on the basis of sex. In the light of case law interpreting the relevant provisions, a trans woman can claim sex discrimination because she is perceived to be a woman. We fully accept the Supreme Court's judgment and have begun to analyse the impact. We are amending the guidance on the public boards legislation to take account of the ruling. There has been commentary as to the implications of this ruling in respect of the Gender Recognition Reform Scotland Bill. This bill was prevented from proceeding to royal assent by an order made by the then Secretary of State. Following the judgment last week, the Scottish Government has no plans to bring it back. While the UK Government has indicated they intend to bring forward proposals to reform the Gender Recognition Act 2004, we have not yet seen any firm proposals. This Government stands ready to engage constructively on any plans following last week's judgment. Gender recognition is a fundamental piece of equality legislation, and let me be very clear, this Government does not support the repeal of the 2004 Act.